Your Honor, on behalf of Ms. Johnston-Hanks, she has fulfilled her duties and obligations under 1334, 100, and 105. She is asking the court to grant the department's petition for termination of parental rights. She has investigated and collected relevant information about Amaya's situation. She has reported to the court about the child's situation. She has observed the child, met with the child, attended court hearings and meetings on this case, and she attempted to speak with Ms. Zayas, but Ms. Zayas refused her effort to contact her. Based on her investigation, she believes that the department has met the elements of termination, and that termination is in the best interest of the child. Well, there's no dispute that 1334, 181A through C have been met. So I'll focus on the rest of the elements. And Mr. LaRosse did a very thorough job, so I will try not to repeat. In terms of services, under element D, there's no doubt that the services that were court-ordered have been expressly and understandably offered or provided to Ms. Zayas, and that all necessary services reasonably available and capable of correcting her deficiencies in this within the foreseeable future have been expressly and understandably offered or provided. And also, Your Honor, I'd like to focus as well on the reasonably available too. That's reasonably available in our community. So what was offered is what's available, and the department is not responsible to create a service that doesn't exist. The services were offered several times in many different formats by many different employees of the department, including Mr. McGee, Ms. Plager, Ms. Ramos, Ms. DeCamp. As Mr. LaRosse said, via text, via email, via service letter, via in-person meetings, as well as going to Ms. Zayas' house. I believe Ms. Ramos said she went there 5 times. The letters and the text are in evidence and supported by the testimony. I also believe that the way that the department approached Ms. Zayas was trauma-informed. Quote from Ms. DeCamp, she tried to meet Ms. Zayas where she was at, trying different ways to approach her, displaying sensitivity in their approach, not blaming or shaming, but using empathy. And that was their approach, and that's evident from the service letters. And indeed, they have to give notice to Ms. Zayas of what her services are, and they have to be clear about what the services are. And they have to give notice and say, if you're not able to complete these services within a time frame, the department has an obligation to seek permanency for the child. So these statements have to be made, even though they are difficult statements to receive. And I understand Ms. Zayas' history and the trauma that she's been through. But I do believe that all of the department employees in this case approached her in a very appropriate way, very professional. The UAs were offered, the drug and alcohol evaluation was offered, the psych eval with the parenting component was offered, the FCAP was offered. And if Ms. Zayas had been more open to doing the services and also sharing her information, we would be at a different point. And I think it's interesting that she did pursue the therapy with Ms. Daybach, but she rescinded her release of information, which limits the department's ability to know what she's doing, if she's attending, how much progress she's making, and sharing Ms. Zayas' records to a degree so that Ms. Daybach can work with her and solve the problems and do the DBT therapy that Dr. Tutty recommended. So based on all of the evidence presented, Your Honor, through multiple different, through the actual exhibits and through the testimony, the services element has been met. In terms of little likelihood, I believe this is probably where the court will focus, as well as unfitness and best interest. The most telling statement is Ms. Zayas' testimony. Several times, I will never comply with the services. And so when you look at the drug and alcohol evaluation, she did do it. As Mr. LaRosse said, she did the stop evaluation. And that's clear from her testimony, but that's, even Mother's Own exhibits 227 and 223 don't show what she's saying is the excuse for the positive UAs that she does have. Unfortunately, in terms of the FCAP, Ms. Zayas didn't participate in that process, which is a huge problem. I mean, if she had engaged with Danielle Bellamy and participated and done the interview, it would have been much more helpful for the overall process. But even without her interview, Ms. Bellamy said, let's try to increase visit time. And Ms. Zayas refused that offer of increased visit time. In terms of little likelihood, again, I think that Ms. Zayas has shown she's making a choice, Your Honor. She's making a choice not to comply. She's shown her choices over time in this case. Here's why it's a choice for her. She successfully did the services in the past. Through a prior dependency, Amaya was returned to her. The case was dismissed. She knows what to do. Another reason this is a choice of her, she is choosing to focus on the lawsuits, which again isn't proving to be an effective way towards reunification. The lawsuits, the theories about the system, the department staff, managers, employees, the theory that the system and the employees are racist against her, it's simply not based in reality. And again, that's this CASA is not saying that's the reason to terminate parental rights by any means, but it's the focus of where her energy is going. It's the mental health component of what she's choosing to put her time into instead of accepting the FCAP recommendation and increasing her visits and trying to get to a point of reunification. In terms of choice, another example, she's choosing her emphasis on the lawsuits above the needs of her daughter. She's tracking where the foster parents lived. That resulted in not only a placement change for Amaya, but also a school change for Amaya that was totally unnecessary. Another instance of choice is Anya can't go. She said, Ms. Zayas said, Anya can't go to the same school where Amaya went, at the Pine Tree Elementary where Ms. Boyette goes. Why is that? That's because Ms. Zayas is so wrapped up and consumed with her energy against Ms. Boyette that she's refusing to put Anya in that school. So what is her option for schools for Anya? That's a choice she's made. The school, also, another example of choice, the school issue with Amaya, the Christian school. No one's saying that Ms. Zayas should not have a say in her daughter's religious choices. That's not what was ever communicated to Ms. Zayas. Rather, the school was a good option for Amaya, who was behind, who needed in-person instruction because of COVID, and she opted out of the religious aspects of that. So, and indeed, I think it's interesting that Ms. Zayas' own Exhibit 211, she is inquiring of Ms. Boyette about celebrating Christmas, with the older kids bringing in cakes, and that she thinks it's interesting that other religions get to pray at work, but we can't even celebrate Christmas. So in this aspect, she's celebrating Christmas, which is a religious activity that she's apparently advocating for, and now against Amaya attending a school where she can opt out of the religious components. That school would have benefited Amaya. It caught her up academically when she was behind, and that is a choice that Ms. Zayas made. Another choice that she's made is to have relationships with the visitation contract providers, her interactions with those providers, that causes her to lose the visit contracts. The example, Jody Davis, fired twice by Ms. Zayas. Then most recently, about a month ago, Ms. Zayas threatening to file a lawsuit and a restraining order, and Ms. Davis dropping the contract again. That impacts her ability to see her child. She also had issues with, I believe, the visitation providers SEMA and Barry. These are choices by Ms. Zayas. I think also the example that Mr. LaRosse focused on is the pediatrician appointment that occurred during the middle of trial, and Ms. Zayas' interactions with the doctor at that appointment, where Amaya was present and heard how she was interacting, insisting that it was a TBI from falling. Further buttressing the theory that this is a choice of Ms. Zayas. Again, the FCAP recommendation. Why would you possibly refuse to increase your time with your child? She said it's because I don't want Amaya to be in the car. But there's ways to work around that. That's why the department has meetings, because they want input from the parent. They want input from caregiver to try to work on plans to increase the hours and follow what the FCAP recommended. That is a choice. Another choice Ms. Zayas made when she had heart issues at the birth of Anya. She agreed to place Anya in the home with Amaya's foster parents on a VPA. And indeed, CPS helped Ms. Zayas, helped her clean up her home. And indeed, Ms. Zayas worked well with Julie Draper. So I agree with what Mr. LaRosse said. There are intermittent times where she will work with people, but who knows when that is or why that is. And that has a huge impact on her case with Amaya. There is diagnosis. Those things, if they are unaddressed, they remain the deficiencies and in terms of meeting Amaya's basic needs, because Ms. Zayas is focused on her mental health issues, which are suing everyone in this case instead of her child, instead of increasing her hours for visits, instead of doing the services, instead of having a lawyer, working with an OPD social worker who would help her, working with a parent for parent program, which is someone that would have been on her side because they've been through the system. And she's refused. And so within the framework of 1334, the option here is termination of parental rights, because that's what the legislature has stated. In terms of, I will skip Dr. Tutty's testimony. Mr. LaRosse covered that. I think Ms. Ramos, Ms. DeCant, Ms. Johnston-Hanks, their testimony addressed the differences between Amaya and Anya, Your Honor. The responsibility of parenting an 8-year-old 24/7, especially when she needs consistency, stability, regular school attendance, a safe home, getting to and from appointments, getting to her doctor's appointments, having a consistent bedtime. These are the things that make her a successful child, that make her a safe child. In terms of Anya, she's much younger. Again, as Mr. LaRosse said, she's not aware of what Ms. Zayas is saying, and we actually don't know what's occurring in the home day to day. And so the distinction is definitely there. And Amaya, again, this is her second case. She's been through at least 2 placements in this case. That doesn't account for the prior placements in the prior case. And that change, that constant change, the change in caregiver, foster parent, the change in schooling, the change in providers, this all goes to best interest as well. Because if this court doesn't terminate parental rights, Amaya is stuck in the dependency case, and we don't know at what point it will end. She's stuck with changes in motion practice, changes in the law, changes in the department's policy, changes in social workers, changes in ACASA, and all of these people in and out of her life who she has to get to know and assess her and ask her these uncomfortable questions about what she wants. So that is the best interest piece. Amaya is the victim here at the whim of everybody else, at the whim of the court. And she deserves not to have that over her head anymore. She deserves not to have to parent herself, not to have to manage Ms. Zayas' emotions and bear those emotions. She deserves to have her basic needs met consistently, predictability in her life, food, warmth, shelter, education. She, Ms. Zayas' interactions with the world, the people, events around her, those are her priorities. That's her attention, and that's where it's focused. And so I submit that the elements of termination have been met. Termination is in the child's best interest. I would point the court to parenting history in Mr. LaRosse's trial brief, as well as the futility of offering any other services in Mr. LaRosse's trial brief. I'd ask the court to find that ICWA does not apply, that the court find the guardianship finding. That discussion was had with the foster parents, and they don't want to do a guardianship. That the sibling finding, which is not a requirement of termination, but it is in 1334-200. I would ask the court to make a credibility finding as well. Thank you.
All right, thank you. So we are going to take our afternoon recess.
Those are from 2015, and that's just the year that I lost custody. So it's kind of interesting that I'm peeing clean, but I still lose my kids.
Okay.
That's all.
So 243 through 272 are all UAs, and they're all dated. So I'm just going to ask Mr. LaRosse, from 243 to 272, are there any particular exhibits that you would like to object to, or the whole, or whatever record you want to make?
I'm going to object to the whole. I had also had some UAs to submit, and the court did not admit those due to lack of foundation, and so I'll object to these for lack of foundation. Hearsay.
Okay. Ms. Zayas, you have to call Cordant Labs. So
I did. That's how I got them.
No, we'll have to have
What,
we have to have a
they have
witness.
to mail it in?
No, we have to have a witness.
Then none of my UAs count at all? Not even the dirty ones?
Well, I'm saying we can get a witness. So, Mr. LaRosse, would you like to hold on?
So you mean that witness that he had dealt with my UA?
Yeah.
She dealt directly with my UA.
No, she was called as a custodian of record.
Oh, okay.
And
So she
he
didn't deal with
offered
mine,
him,
though.
and you
I objected.
you objected
No.
you objected to.
It was my medication anyway, so I wouldn't really.
That's why
object.
you objected, but you didn't object to them being offered as a business record.
So you mean to tell me none of my clean UAs are going to count?
Mr. LaRosse, would you be so kind as to provide Ms. Zayas with the contact information for it's not Ms. Briggs, it was somebody else, wasn't it?
I threatened to sue them. They're not going to talk to me. I'll sue them for this. Fuck that. They're crazy.
Well, if you ask the court to issue a subpoena, Ms. Zayas, the court will issue a subpoena.
I don't know how to do that. I'm not a lawyer.
Well,
lawyers fuck me over.
All you have to do is
fuck me over.
All you have to do is
I don't need a lawyer.
ask. All you have to do is ask this court.
Ask who?
Me.
You tell me this on the last day.
Are you asking this court to issue a subpoena for the witness from Cordant Labs?
How's she going to testify to anything from 2015?
Okay, can I just interject for 1 second? Because I have a suggestion. I haven't had an opportunity to look at these. I will attempt to do so over the break, and maybe we can come to a stipulation.
Okay.
I'm not sure I'll be able to do that within the time allotted, but I will try.
All right, very good. We'll revisit these after the break, and then Ms. Zayas, if there's not an agreement among the parties about these, then you can ask this court to subpoena the witness from Cordant Lab, and I will.
Then wait a minute. Then how come every time I said that email's not relevant, you let him submit it, and you didn't take down any of my objections, and they were just emails talking about random shit. I mean, how did that have? But you don't want to submit something that makes me look good, but you want to submit something that makes me look bad. I see where this is going. Okay, I see where this is going.
I will issue a subpoena for the witness from Cordant Labs if necessary. All right, go ahead. Let's move on to 273. And 273 is the WAC 110-148-1525. Ms. Zayas, are you offering 273?
Sorry, I had to answer the door.
Yep. Are you offering 273, which is WAC 110-148-1525?
I think that's the one that says, my computer's slow, hold on. Homeschooling. Number 2 says homeschooling, private schooling, alternative learning, blah, 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 blah. All children in care are prohibited for all children in care and custody of the department unless approved by a court ruling. So that's, but they thought they were going to be able to hide it from me is why they never told me. But.
All right. Any objection to 273, Mr. LaRosse?
No objection.
Ms. Cowan?
No objection.
All right, 273 is admitted. 274.
I put this in there for, wait, which one are you on?
274.
274. I don't see this one there. This is the dependency that, in 2017, they were going to take on my, because I wouldn't submit a drug screen. That was the reason they were going to take her. And that was just, I put the box around that particular reason because I just, that my jaw just fell on the floor. So that's, and I never even knew this existed. And I just refused to talk to them at all. And they were already plotting on taking Amaya long ago. So it's been like a stalking thing since she was born. She's been stalked by these people. It's unlawful. That's all.
Okay, so are you offering 274?
Definitely.
Okay, Mr. LaRosse?
I'm going to object on the basis of relevance and foundation. What we have here is a unsigned draft of a dependency petition that does not have a case number, does not seem to have been filed or entered by the court regarding the now adult sibling Marcel, guess was drafted in 2017. I'm not entirely clear. I'm trying to figure this out when it was drafted, but relevance hearsay foundation.
Ms. Cowan?
I object because it's not assigned. It appears to be a draft, so I guess foundation, not the final version of the document.
The court will sustain the objections to 274 and refuse 274. It does appear to be a draft.
It proves racism, basically.
So then, Ms. Sayas, you uploaded a number of things over the break that haven't been numbered yet. Let me just, the next one of them had a problem. So you uploaded an exhibit that says exhibit 1005 XPS and it's not working. So
yeah, I put it on PDF. It's
okay
on PDF.
All right. So, okay. So what we're going to do is take our afternoon recess. It's 2:30. Let's take an extra, how much, like 5 minutes? Let's take an extra 5 minutes so Mr. Mason has time to number the remaining exhibits. And then we will resume at 10 minutes to 3.
I'm going to delete that XP.
Okay.
Since it's not a meeting.
Okay. So, Ms. Ayes, Mr. Mason's going to delete the exhibit that says 1005 XPS because it doesn't work.
Yeah.
Okay.
Okay.
And then he'll renumber what's there. And then we will see each other at 10 minutes before 250. Thank you, everyone. 275, I think, is the next one.
Your Honor, can we talk about the UAs?
Oh, yeah, for sure. Sorry, I forgot about that.
Let me just see here. Is Ms. Hayes back on?
Mm-hmm.
Oh, there she is. Okay. So I don't know if parties saw this, but I sent an email suggesting that I would stipulate to entry of the UAs 243 to 54 if Ms. Zayas would stipulate to entry of departments 176, which were different UA results that were previously rejected by the court. But I would object to exhibits 255 through 272 on the basis of relevance, since those are UAs from 2015.
Okay. So let's start with the offer to stipulate to 243 through 254 if you, Ms. Zayas, stipulate to 176.
How does all my 2015 other stuff matter, but this doesn't matter?
Well, we're going to talk about 2015 in a minute. I just want to know if you will agree to 176 coming in exchange for your Mr. LaRosse's agreement that 243 through 254 come in without you having to call the witness from Corden.
Yeah, but then, well, I don't know what he's talking about, but yeah, that's fine. I just
okay. All right, then we'll get to the other ones in a second.
On the medication. Yeah.
Okay.
Fine.
So 243. So 176 is admitted now by agreement, and then 243 through 254 are admitted by agreement. Okay. So now let's talk about 255 through 273, which are UAs from 2015. Ms. Zayas, would you go ahead and respond to the relevance objection? Why are these 2015 UAs relevant?
Because it proves they're oh, well, I will stop saying they're racist, that they discriminate and favor African-American men.
And how does it prove that?
Because I was clean and I lost custody of my children to people who were not clean. And that will come later and you'll see that they didn't do anything. But it's relevant because that's the reason why I'm being harassed today by them. It started with something, right? It started with someone contacting me. And the reason that the certain someone contacted me in 2017 was based on not because they were scared for Amaya, but because they commonly do particularly harass white people.
Okay. So you said something that's interesting to me. You said that will come later. And so I'm going to reserve on the relevance objection to 255 through 273 until you testify. And then you can, during the course of your testimony or the testimony of witnesses who you may call, try to establish the relevance of those. And then you can offer them again after you've presented some testimony. Does that make sense?
The drug screens, you mean?
Yeah, because what I hear you saying
No,
is...
that doesn't make sense. That does not make sense because my child was taken for dirty pee. This is what my child was taken for. One dirty UA 30 months ago. One. And I'm submitting 50 and they're saying I'm on drugs for 15 years. That's a lie.
Oh.
You see all those clean UAs.
Okay.
You know, that's their testimony is that I'm such a drug addict. And I'm trying to prove to you that I'm not, and you're not submitting it. That's just...
Okay, now I understand. So what I hear you saying as far as relevance is that the department has, during this case, presented evidence in support of their contention that you have not remedied your parental deficiencies, that you have a long-standing
Yeah, they
use
can't
of
take kids for parental
methamphetamine.
deficiencies.
Okay.
That's against the law.
Okay, but you are offering 255 through 272 to rebut the department's assertion that you have a 15-year
Yeah, I mean, they're
use of
going to terminate my
methamphetamine.
rights.
Okay.
Yeah, so I think that this is kind of just a little bit important.
Okay. So, Mr. LaRosse, with that explanation of relevance that is being offered for the limited purpose of rebutting that assertion by the department, do you still object to relevance of 255 through 272?
Sorry, I'm just thinking.
That's fine.
I mean, insofar as the court is accepting them not to prove that Ms. Zayas does not have a substance abuse problem or has not had a substance abuse problem, but solely to demonstrate that she was able to provide some clean UAs in 2015, I think that has very limited relevance, but I would not object if it's submitted solely to demonstrate that she in fact did have some clean UAs in 2015.
Which would be evidence contradicting the department's assertion. And albeit, as you say, limited relevance, but some relevance.
Yes, well, the department is not asserting that she never did clean UAs. She did services in her prior dependencies.
But the department is asserting that she is has over a 15-year history of substance abuse disorder. And this is relevant. This is evidence that tends to even slightly disprove that. And so I understand that your position is it has slight relevance, but under 104, it may be slightly relevant. So that's what it's being offered for. So with that, if you still object, then that's fine. I just am clarifying.
I do still object.
Okay. All right. Ms. Cowan.
No objection.
Okay. And Mr. LaRosse, are you withdrawing your objection to hearsay for 255 through 272?
Sure.
Okay. All right. So,
But you submitted all his emails,
hang on, Ms. Ayers. All right. 401. I said 104. I flipped that. 401. 401 says relevant evidence means evidence having any tendency to make the existence of a fact that is of consequence more probable or less probable. And so under 401, this evidence has a slight tendency to make a fact less probable. And so, and the court agrees, it does not contradict, it does not disprove a substance use disorder. It is just relevant to whether or not Ms. Zayas has an ongoing 15-year substance use disorder. So the court will overrule the relevance objection and admit 255 through 272 for that limited purpose. Okay. All right. And I appreciate the parties working out an agreement on the other. That was very efficient of you. Okay, let's move on then to 275. I think that's the next one. Ms. Zayas, 275 is a guardian ad litem declaration. Are you offering 275?
Okay, my explanation for this one is the same as this court does, the antagonizing thing. This is what the last court did, the last people did. But see, back then, they didn't used to hide. They came out, they did it like as themselves, which is crazy, but they used to do it as themselves. Now they work through puppets. That's what these people are. 275 is just proof of repetitive discrimination. And what they're doing is they're saying these things in this court order that they know will hurt my feelings or make me sad or whatever, and then they wait for my reaction. Janice Bridges, I don't know if you know her or not, she's trying to be a politician now. But back then, she used to write these things hoping that I would be so upset and crazy that they could just record my reaction and look what we're doing to your kids and you're not getting them back, basically. And that's what they did. They said, look what we did to your kids and you're not getting them back. And they would write it out in the court documents like this. And they thought it was funny. And then, but they never submitted this because they never intended to help me. That was not the point. They just wanted me to see exactly what they're doing. And this is common in these people right here. They do the same thing. They wait for my reaction. They do dumb stuff. They try to hurt my feelings and tell me things like, are you sure you don't want Maya to go to a Christian school? Like I didn't just say, duh, don't. But this is the same thing these people do. They antagonize. This is intentional. This is reverse racism. Because I accused them of racism a long time ago, from day one. I used to have a black judge, a black lawyer, a black everybody. Now they use white puppets. Okay, it's the same thing, just white puppets, just a little different. That's all. They control everything. They control everything that these people do. And I don't even think that the puppets know what they're doing. Like they probably really think that they're, I don't know, cool or something, but no, they're not cool. They're not liked. They're being used. But I'm going to grab my daughter. Hold on.
Okay, yep.
So this is important because this is my whole case, basically. I'm not here because of a drug screen. They don't care about drug screens. Trust me, they don't care about drug screens, and I'll show you why. But they just find whatever they can that's insignificant and make it into something drastic. And it's just all an act. This is probably an act. My trial is probably an act. I bet it is, but it's like funny to them. They enjoy torturing, I don't know, white children, I guess. I'm not sure, to be honest with you. But this is the man who they gave my child to was black, and he didn't do any services at all. And I told them to please not send my daughter there because he was asking me to do favors for him sexually, and I wouldn't. And so I said, if you put my daughter there, he's going to do something to her. And they didn't care. They did it. And this is the letter right before they took my son out. And my daughter said the reason that she was obviously scared is because her brother left. And that's coming shortly. But basically, they did this on purpose. And this is intentional, just like right now is intentional. This is happening. It's intentional. It's retaliation. It's been 30 months and one drug screen. And I've never done anything or complied or signed or anything. One drug screen, 30 months. That's retaliation. That's hate. You have to hate a child to do this to her. You have to hate her. And the only thing that defines hate is what? Discrimination. You don't know her, and you have to hate her. So that means you discriminate against her because you don't know her, but you still hate her. These people hate Amaya because they would not be doing this to her if they didn't.
Mr. LaRosse, your position on 275.
So 275 is a copy of an unsigned declaration of a guardian ad litem in Jasmine's 2009 Pierce County case. So I would object, and it doesn't even mention really the mother. I would object on the basis of irrelevance, foundation, and hearsay.
Okay, Ms. Cowan.
I agree with Mr. LaRosse, and also some of it goes against what what Ms. Zayas was saying in terms of what it represents at the end of the document, but thank you.
All right. So the court will receive the testimony that Ms. Zayas just gave about
But they'll
her.
never submit any proof of racism ever.
I will receive the testimony that Ms. Zayas gave about her experience with the department in the past and how it has impacted her. And
But when you submit everything, you're not going to have anything of me saying that, because you're probably not even recording this. I bet you money you're not recording
I
this.
am recording
And
this.
no, you're probably not. But it's not going to go on the official record or something. You'll take it off, whatever. They already did it. I don't care. But all this stuff that I attest as to why I'm here right now, this is why I'm here right now. Because they're black and they hate me. Okay, I don't care if you don't believe me. I know because I've already been through this before. So when I already see the mole, the problem, you know, I call it how it is. There's no other reason you should hate my child this much. There's no other reason you should have me here right now. Marijuana is legal. People are getting high all the time, and probably with their kids in the room. But you're freaking out on me? Like, really? 30 months? Oh yeah, you guys. That's a no-brainer.
And so I will receive all of the testimony Ms. Zayas has given into evidence. 275 will be refused because it is not signed or and its factual content is less relevant, frankly, than Ms. Zayas's testimony, which essentially outlines her experience and her evidence that the department has acted with a bias against her. And so I'll refuse 275, but allow the testimony to stand. 276.
Proof they favor black men because they gave him custody and he was in prison the entire dependency, didn't do a single service. And I have proof of that coming too. So this is the reason why they hate me, because I have black children. See, I don't know if you know or not, but they really hate that. They hate that worse than anything. It's like I can't even explain it. I never knew either. If I would have known, I would have definitely dated white guys. This is a big problem, I guess. I didn't know they hated me. As a matter of fact, until 2020, that's when I got my discovery, is when I learned that was why. Back in 2011, I always thought, yeah, they're racist, but I thought the judge was racist. I didn't think they were racist. And then when I got my discovery, that's when I realized that, because I didn't know that he didn't do anything. He didn't do a single service. And he thinks it's funny, but he got custody of my son, and that's the custody paper right there. I also added his sentencing paper where he was sentenced to 50 months in prison. The entire dependency, he was gone. They gave him custody before he got out of prison. He got custody of my son. On the phone, about to get out of prison, got custody of my son. And they had me go to that court date and sit there and listen to that. I don't know. They're weird. But I thought he had done the services, and he didn't do anything.
So,
You're welcome.
Ms. Zayas, this looks like an order for child support, financial support. Yeah. Am I missing something?
Yeah, I know it's weird because it went from dependency. They didn't adjudicate it. It just went straight to a plan, a parenting plan. They did not adjudicate the dependency at all.
And so, paragraph 2.3 is the only thing that talks about the children being taken from you and placed with Mr. Bradley. Is that the portion that you are directing us to look at?
Just the fact that he has custody of my son. And when you see the dates that he got out of prison within, not even a month out of prison from doing 5 years for selling crack, and they just gave him my son.
Okay.
And that was the whole intention. That's why they dragged it out for 6 years, because they were going to give him my kid. Yeah.
Okay. And will you be testifying about the circumstances of that later?
Yes, that's
okay.
That's all included in, and that's how it started with Amaya too, is him calling. He called CPS on me saying that I was making his son watch Amaya while I was at work. And that's how they started harassing me in Kent. That's how it all started.
All right, Mr. LaRosse, what's your position on 275?
Well, it is a court order, but I cannot fathom what relevance an order for child support in a non-dependency proceeding that modifies the child support entered in 2015 has to this proceeding. And it says to Marcel, who's not a subject of this proceeding.
Okay, Ms. Cowan?
No objection.
Okay. I will admit 276 for the evidence that that's contained in paragraph 2.3 that the children were removed by the children or the child was removed from the mother's care by Pierce County Juvenile Court under dependency action and placed with the father, Mr. Bradley, on November 24th, 2014. I'll admit this with the expectation that Ms. Zayas is going to give testimony about it, and the relevance will be established during her testimony about her experience with the department. Again, and that it goes to it's evidence that's relevant to her mental health issues that the department has raised, and whether they are a result of whether her extreme reactions to the department are based solely on mental health or if they're based in her experiences. So I'll admit it for that limited purpose. 276 is admitted.
Are we 278 or 277?
We're 277. And with 277,
Oh, that's the same thing?
no, 277 is the parenting plan final order.
Oh, and he didn't let me see my son for 2 years. I didn't see him for 2 years when he got it, and the judge approved it. No visits for 2 years. It was beautiful.
Okay, Mr. LaRosse, 277.
It is a court order. I do not see the relevance to the current proceeding, so I object on the basis of relevance.
Ms. Cowan?
No objection.
So this exhibit does provide evidence in support of a 15-year substance abuse history. It's a court order that makes it has implicit findings about that. So, and finds that an explicit finding of a long-term impairment resulting.
Are we on 278 or 277?
We're on 277. So paragraph 2.2 says the mother's involvement or conduct may have an adverse effect on the child's best interest because of the existence of the factors. And it says neglect, the dependency case, and then a long-term impairment resulting from drug, alcohol, or other substances. So that is relevant to this.
But he was part of the dependency, and he didn't do any services.
Yeah, I understand. Let me finish making my record about why I'm going to admit it. So it is relevant evidence to the topic of the longstanding substance use history. And it also is evidence that Ms. Zayas will, from an offer of proof, will be discussing her relationship with the department and how that has impacted her, and explaining a reason for her extreme reactions to the department. So it has evidence of both of those topics within it. That's the relevance of it. It is a court order, so the court will admit 277.
That's my understanding as well. So I agree with Mr. LaRosse. I also object to Ms. Zayas' testimony about as hearsay on the policy that if a child's removed for a second time, the department has a policy that they won't return the child.
Okay.
I can submit the whole discovery, and I'll just give you the page number, and you can look it up yourself.
Okay. So with respect to the testimony about the policy of the department, the court will strike that testimony. With respect to 278, because there is at the top of page 7, there's another hearing set. The court finds that the purpose for which Ms.
Okay, can I give another purpose then?
Yeah.
Okay.
Well, let me finish what I was going to say, and then you can.
Go ahead.
So the court finds that the purpose for which it's offered, which is that the court struck further hearings, is actually not consistent because they set another hearing. So, okay, go ahead, Ms. Zayas.
The court ordered them to pay for treatment, and they never did. Drug treatment. They said.
Direct me to the page in line where it says the court orders.
I think it's page 5. It says page 5 number. Yep, number 6. If Ms. Zayas has a positive UA, then she shall participate in blah blah blah. And they said that they never paid for it. I applied for a DATSA like 1,000 times and sat there for years. And then they said, "Oh, you took too long," and sent my daughter away with weirdos. So
Okay.
yeah, they did that on purpose.
I will receive that testimony. I will not admit 278, but I will receive the testimony that the court ordered the department to pay for treatment, and that Ms. Zayas is testifying that the department did not assist her with getting funding for treatment.
Then why don't you just submit the whole thing?
Because I'm accepting your testimony as to that.
But you don't want to submit anything that says anything that the department did wrong, huh?
I'm accepting your testimony that the department didn't do what
I
the
know,
court
but it seems
said.
like you just don't. You will accept every single of his emails that are. You don't even know if it was me, but you'll accept those. But you won't accept anything the department did wrong.
Well, and the court will take judicial notice that this court, judge or the commissioner, Dickey, on February 1, 2010, ordered the department to pay for drug treatment, and the court will accept that as a fact because it's captured in this order. So.
I would like for there to be a record of me having my children taken at that time. That would be nice, because even though we all say it, it's not on the record. It's not on documented proof. There's no documented proof of that.
Go ahead,
I never had a shelter care hearing.
Okay.
So.
Go ahead, Mr. LaRosse.
Yes, so Your Honor, I would object to the document being only partially admitted, or only parts of the document being admitted, because for purposes of completeness, it's important to see not merely one thing that the court ordered, but everything that the court ordered Ms. Zayas to do. And so
that is a complete order. I never had a shelter care hearing. I didn't get that till 4 months after they were taken.
What I'll do is withdraw my objection to admission of the complete document, because if the court is going to admit it in part.
That is the complete document.
Hold on, please. I would request for the whole document to be entered, and then at some point I'll see if I can find the petition that accompanies it and request.
You won't find it. They didn't have one.
So all I'm doing is taking judicial notice of an action by the court. I'm not admitting the document in part.
Oh.
I'm taking judicial notice that the court did order the department to, specifically it says, assist in securing funding for treatment. That's the only thing that I'm taking judicial notice of. I'm not admitting anything else in the document. I'm not admitting any part of the document. I'm just taking judicial notice of that event. So,
I'm sorry, I misunderstood.
yeah, so 278 is refused. All right, 279. Go ahead, Ms. Zayas.
Well, you're just refusing all my evidence, so I'll just throw it in the garbage. This is his sentencing, where this, man who did nothing at all was sentenced to 60 months during the dependency, and they gave him custody of my son upon his 0. And only because they wanted my child's placement to meet their ethnic and cultural needs, and I couldn't meet those needs because I'm Caucasian. That's what the judge said. So that's real. That really did happen. And
Objection hearsay.
I can't get it because it cost $300 for that. But I was trying to get it. But
You were trying to get what for $300, Ms. Zayas?
The audio to that, her saying that because I'm Caucasian, I can't meet my children's ethnic and cultural needs, and that only the fathers could, and that it's time for the children to be with their roots, because she did say that in court. And this is his sentencing that proves that he was gone the entire dependency in prison, and he still got custody of my children, or my child. Nana? What's the matter, Mom?
Okay. So the objection to hearsay is sustained, but Mr. LaRosse, what's your position on 279?
No objection.
And Ms. Cowan?
Well, Your Honor, my 279 is an order.
Is a stipulation on prior record and offender score?
Yeah, that's...
All right, refresh your share file.
Okay.
Sorry.
Let me...
What is your 279, Ms. Zayas? Is it the order of dependency as to, or was it something else?
My computer's.
That's weird. Okay, so now it's an order of dependency.
This is what I was saying that I would bring later and tell you guys that it's written on paper that she was molested by her father, but
Okay.
you know, of course, lightly because they do everything lightly. But that's on page.
Wait, are we talking about the dependency order now or that criminal order?
So we're talking about what is marked as 279, which is the dependency as to the mother, Ms. Zayas, dependency of Jasmine Zayas.
Yeah, right here. Okay, so page 3. It's just they say it in a little insignificant. Of course, they don't want to get in trouble, but there are 3 instances in which she woke up finding her laying on top of her or near her bed. But she describes pushing her and telling him that she would put a chair against the door to prevent him from coming in.
It's so fucking depressing being here. Nobody wants to be here. Imagine living every day without your child, while the local government shares your children with foster to adopt parents that desire to adopt your child for reasons that are unsubstantiated and illegal under no laws at all. They operate these judges forcing illegal adoptions. 100% of the time in the state of Washington County, a king city of Seattle, it's a miserable existence to live in. I will be compensated for the crimes committed against me in cash. I will publicize everything they did to me and my children. I've wasted too much time. I refuse to waste another second. My son is gone. He passed away because of them, because of their domestic terrorism against us. The Department of Children, Youth, and Families needs to be abolished. They are the second most useless government agency in the United States. The Department of Justice needs to stay away from other people's children that don't belong to them. The FBI supports child predators dressed like judges. I'm never gonna be quiet. I'm never gonna close my mouth. I'm never gonna stop saying this. I'm never gonna stop singing this. I'm never gonna stop talking about this. I'm never gonna stop exposing them, because that's what they get for wasting my life. Don't waste yours, my best piece of advice. Just never tell them who the other parent is. If you can keep that a secret, don't tell the government at all. Ever otherwise, you will be locked in the years of complete terror. For money and satisfaction, they love doing this, and it's highly concerning. Homeschool your children. Public school is the worst thing that can happen to any child.
I don't know how these people expect me to not sue them, because you took my job again. Okay, that's the 3rd job in 2 years. I can't keep a job to save my life. And you know what's crazy is that every time I get fired, I know that, you know, it's probably because the person who's firing me is afraid that their children are going to get taken too. You know, they don't want their kids to be messed with. So yeah, no, they're scared of these people, because that's what they do. They bully people, and they come with like their government employees to try to, you know, change things. You know, I noticed it right away at my job. You know, all of a sudden we're getting all kinds of inspections and everything, and it's like all of a sudden, you know, because the government's so mad that I have a job. Oh my goodness, what's gonna happen if I have a job? Oh my god, everyone's gonna find out the secret. They already know. Just because they don't tell you doesn't mean they don't already know. Everybody knows. Kids talk, okay? They talk all the time. They talk more than grown-ups. My kids were school age, so hello. They talk to each other. Do you know that people who don't even know my daughter probably know the whole story way off in some school way in Eastern Washington, okay? Guaranteed they know. Everybody talks, especially kids. And it just goes like a rumor mill, like he said, she said, and it probably changed to like 10 different stories, but it's still there, and they still know who you are. So please believe, understand, and know that everybody already knows. The damage is already done, okay? So the more you keep, you know, taking my job, the more I'm going to be able to talk about it on this channel. And the more I have to talk about it, the more fresh my content. Times the order, no, they cannot do it, period. So, and it's sad that it took me this long to see the big picture, because, like I said, trauma will blind you for years. You know, it will. It'll make you blind to the truth. And that is unfortunate, because they play on that trauma. They thrive on that trauma. They hope that the trauma comes, and they do it in the worst way on purpose. They commit all the big crimes on purpose, the perjury, forgery,
fraudulent documents, everything. It's intentional to distract you from the fact that they're not even supposed to be doing any of it. Under any law, they don't have at all. No laws, zero. Not in my state anyway.